Hey, everybody.
Me too.
I'm excited to have a conversation with my friend, Darlene Tonelli. I am Mike Whalen, host of the Contract Teardown Show. Darlene was on one of the most popular episodes of the Contract Teardown Show, the MSA for Salesforce, I think it was. And so we're excited to have her. This is a new format for us, this learning lunch setup. We're going to keep it light, conversational, a little war stories-y, try to give you some insight into the reality. We're going to be a little more honest, a little more open probably than this is still recorded though, Darlene. So you can't, you know what I mean? We can't do too bad. I saw somebody say today on Twitter that they were doing a lawyer lunch, which was an energy drink and anxiety. So this is a learning lunch. Hopefully you guys are eating something better. Darlene, I want to talk about you real quick. How are you today?
Great. I'm excited.
So, Darlene,
Always.
we're having you on because you and your company are engaged in some of these software deals that a lot of people are interested in. Your personal background is in entertainment and media law, but you started in inter alia law, and your firm deals with a lot of software deals. As we get started, sort of give the context, the framing for why these kinds of deals are so troublesome. What is it about this SaaS environment, this software environment, that gets salespeople wound up and speaking one language and the lawyers speaking another language, trying to slow things down?
So I think to set the stage why I thought that this would be a great one for anyone dealing with SaaS contracts is that the challenge is if we look at a typical scenario, you've got sales that is focused on revenue targets. They receive commission, they're focused on sales. And often in the various companies that we work with, there's this dynamic where almost sales and legal are viewed to be doing two different things, when really sales and legal are both selling the same product. They have different roles in the pipeline, but they are not at odds. And what inter alia has been trying to do over the sort of decade that we've been working on these deal processes is to try to bring everybody together. And so we promised a formula. I don't know if it's a formula, it's not particularly scientific, but for anyone who does these deals, I think that they will recognize themselves in either, I don't know if there are sales people on the call or legal, but usually sales brings in a deal at the last minute, where I'm talking SaaS vendor deals. So just to give you the right background, you've got a contract that your company uses, and the sales team is tasked with getting that contract, getting it over the line. And usually legal gets it at kind of the end of the process. And that's where the trouble starts.
Okay,
Not
so let's
battles.
frame this. I want to frame this because these software deals, somebody asked in the comments, wait, what is SaaS? So these software as a service deals, right? That these happen all the time. And you and I, when we started this conversation about what were we going to talk about in this, what we were going to talk about in the session that we're going to announce later, in the workbook that we'll talk about later, what's the framing? And I think this is important because a lot of times when you go to a continuing legal education program or something, it's sort of generic. These are the updates in whatever area of law. That's not what we're talking about. We are taking a position. We are speaking from a position so that, people know kind of the stakes. And the reason I think that that's important is because there's a big difference between, I don't know if this is an industry term, if it's just my term, but an inbound contract versus an outbound contract, right? We are talking from the perspective of an outbound contract. I work at a software company. I'm in-house counsel. Our team is trying to sell software outside. There's a lot of issues in software that, get sales and legal on different pages, but I maybe underline for me why that understanding that perspective is so important in terms of legal being able to preserve or prove their value.
So I think everyone dealing with contracts wants to be known as a facilitator. They want to be known as the person who's not the block. So anyone who's done a contract where you're managing the in-house agreement, like you've just described, the pain of everyone being really excited about a deal and then having all of these last minute discussions that can stop a deal, frankly. So what we always try to do is build the process so that, and why it's important is that if you don't have a process, if you're just reacting and you're leaving it to the lawyer to deliver the bad news to everybody at the end of the day, actually, there have been a lot of failures up to that point. It's just that it tends to get pinned on legal, if I can put it, that's the way that I would explain it. So if we don't get in front of making a process to deal with SaaS licenses, you're just reacting. So you're having tough conversations when you're basically forcing your decision maker at the company to do something they don't want to do, either to take on more risk than they want or to kill the deal. So what I get really excited about, and I'm not even joking about that, I know it sounds so weird, but it's so true, is that when the lawyers and the sales team get on the same page, when you work like you're both in the same transaction and that you're both a key part of it, it's just very rewarding for everybody. And it's the recipe, in my opinion, for happy lawyers in-house. And it does improve revenue for the company. So why we're talking about the actual process is that I think the nuts and bolts, we'll talk about, yes, we can talk about the nuts and bolts at some point, but everyone's kind of working with the same nuts and bolts. And what I observe in all the different companies we work with is that sometimes there just isn't a process. There's just no one's thought about this. So I could set out like 3 tips that I think would work for people to think about if you want.
Yeah, please. So again, the idea is sales has kind of been on their own island, talking to the customer directly, the potential customer directly, making a pitch, making an offer. Hey, I love this. I want to buy this. Cool. I want to sell this to you. That's when legal's coming in the typical scenario, and just, by that process, it becomes a bottleneck. How do you stop that? Give us some tips on how you stop that kind of really late handoff. Is that just endemic to the process, or is there something we can do to get legal involved earlier?
I think when it happens late in the process, it can happen late in the process, but only if you've built it out properly. So I think number 1 is to get in a room with sales at the beginning. So one of the things we always do is we just say, can we talk to the sales team? Can we look at the document together? Because one of the old jokes when I was in-house counsel before was always like, hey, Darlene, print me a contract. This was the sales and marketing team. And what I realized, although that was like very annoying at the time, what was funny about it was that I realized that, these terms aren't, the time to explain the indemnity and the risk is not when the deal is about to not close. Nobody cares. You're like the Charlie Brown teacher, risk. And then you kind of wear that. So what I like to do is get in a room right at the beginning with the contract and the decision makers and talk to, have the CEO there, the CFO, the head of sales, the lawyer, and talk about what the company can sell. So you sell a product that handles personal information. You cannot take on uncapped liability for the reasons that the company has, or you're not able to get insurance for a particular risk. Sales needs to know that, and they need to know that from the company head, not just from legal, so that you can talk about what they're entitled to sell. So if it's a product that you can't have uncapped liability on, sales needs to know that and start messaging it at their relationship stage in the process. And so getting in the room and just having everyone understand that you're in the same process is step number 1. And you'd be amazed how rarely that happens, especially when you're in a startup, a scale up. It can happen that there's been no real thought to why you have that template. A law firm gave you the template, you're trying to get it out there, and you're not doing it. You're not engaged with what it says and your role in making that be understood by the person buying the product. So that's number 1. That makes sense?
Mm-hmm. Yeah, keep going. What else?
Okay, number 2. So the other thing that I've observed over the years is that often when the lawyers are arguing at the end, you're dealing with a scenario where the lawyer on the other side is also getting flown in at the very end. So they don't know what the product is about. So if your contract looks very different from the sales pitch, you're going to have a disconnect. So often with our clients, I will actually say, can I see your sales deck? What are you saying about this product? Because, as a simple and straightforward example, if your client sells a burglar alarm, if the sales deck says that they are preventing burglaries, the lawyers are going to have problems, because the lawyers are going to get all kinds of questions like, well, how many burglaries do you prevent? Do you prevent 100% of burglaries, or do you prevent 99% of burglaries? When really, if you change the sales document and it now says, we detect, improve your chances of detecting burglaries. We monitor your premises, we do the following items. Then when you get to contract stage, then you commit to do those things. So that is huge. And honestly, so often, the reason why this matters again is that you haven't sold the product really as a salesperson if you have gone and sold that you prevent burglaries, because you can't sell that product and your company cannot sell that product, or they will be on the hook for all the costs of the client having a burglary, which isn't fair or right, or the product that they're selling. So just aligning the sales documents all the way through the process and working with the sales team to have them get their business team that they're dealing with on the customer side to teach their lawyer what they are buying, honestly, is half the battle, because there are two sides to the discussion. And what I see a lot is that by the time it gets to legal spends all this time explaining to the other side why we can't accept their proposed changes to the vendor's agreement, when it's really honestly half of what we're doing is educating them about the product. So whenever that happens, if I feel myself in that discussion, I'm just like, okay, we got to go back. We got to make sure that legal is not the one explaining what the product is, or we lose time. We accept more risk than we want to, and everyone's unhappy. Like the lawyer feels bad, salesperson feels bad, and it often is presented like, oh, legal killed the deal. But that's not what happened at all. Actually, the deal was never going to happen because you sold a product that this company can't sell.
All right, let me underline. Tip 1 was legal, share your paper with sales beforehand in a way that is adapted to them. Sales, share your paper with legal, what you're promising so they know, right? And then what's the third? And I'm framing this because I want to give you pushback or clarification that Ken Berger shared on here in a second that I think is really interesting. So tell me the third tip and then we'll pivot to that.
So the third tip is just to give tools that allow sales to have more of a role in the process earlier on. So for example, that can look like a playbook. It can look like step back positions that they are authorized to negotiate. This is going to depend on your sales team and how contract savvy they are. And there is a range in sales teams for across companies. So you would need to have your sales team, like who you have on the team, inform the process as well. But if they are savvy contract teams, which many sales teams in SaaS are, then you give them a couple of step backs so that by the time the document arrives at legal, you're dealing with the real red flag issues that are outside the bounds of the playbook.
Let me just read from Ken. He said the real world point here is competition. The salesperson is working 2 to 3 years sometimes just to get a meeting, and when they finally do, they begin to have meetings. Bringing in the lawyer early on is just a killer. It goes over like a lead balloon. He said, I think that actually underlines something that's business-wise really interesting for the lawyers to understand, which is that not all SaaS companies, all software offerings are not created equal, right? Some companies are looking to have large enterprise transactions. These are sales-led organizations. They have a really long sales cycle, to Ken's point. That engagement, how a lawyer engages with that kind of circumstance might be a little different, maybe not. I'll put that question to you. But then the other kind of organization might have more of a business to consumer sort of approach, that it's more marketing led. They don't have a large sales cycle. They have a lot of printed materials that, marketing materials that go out that legal is looking at beforehand. When you make the argument, let's get people in the room before sharing their points each way and making a plan beforehand, does that change based on, are these highly customized sales or are these highly systematized sales?
So these would be, I would say that the sales we're primarily focusing on in this discussion are where your vendor doesn't just dictate the terms. So this is a scenario where there is negotiation. There is a bit of flex in the terms because there needs to be for bargaining power reasons, right? So this would not be the large vendor imposing their standard terms and just having an order form. This is sort of like, okay, we're scaling up, we're a startup, we don't exactly know where the sale lands with the legal terms. And that happens at the beginning. So you can't dictate the terms from the beginning, especially if you're cutting new ground with your product so that people don't really fully understand exactly what you're doing or what the risks are to them from using your product. So I would say it's that negotiated scenario. And when I say get in a room, to the point of the commenter, I don't mean with the other side. And this is a key clarification. I mean with your own team. Get in a room with your own team like you are a team and you are both engaged in the same process. I agree that leaving the lawyers out until the last minute, particularly, I definitely don't recommend lawyers being in the room for the sales process. Everyone does their own thing that they're great at, but I recommend that the sales team, when they're out selling, are selling something that isn't going to stop at the door of the legal department. And that's the discussion that I think has to happen. Because absolutely, the sales team is competitive. They're dealing with a quarter end. They're compensated on revenue. They have targets they have to hit. It's very stressful. And I think that there's too much stress in a lot of these startups and scale-ups stacked on the legal and sales relationship as a result.
Yeah, I feel like there's something here in the sense, like going back to our conversation on the Teardown show about the Salesforce MSA, Salesforce doesn't ask for permission, right? They're a big enough company that they're going out and they're saying, this is the contract. So if I'm sales at that company, at Salesforce, if I'm trying to get companies to adopt and take on Salesforce as a tool, that meeting beforehand it's almost not like, let me orient because we're going to have these real long negotiations. But I still think that meeting is important because sales needs to understand what they can offer and what they can't offer. And I'm thinking of marketing in that room too. There's so much written content that says we're going to promise this and that and that. And then legal is in the back room going, what the heck are these people talking about, right? Like, so that meeting still happens. But to your point, with these sort of complex deals, these long line deals where there's a lot of back and forth, those communications early on make it so that the deals later can happen. How, you wanted to talk about the specific terms, the terms that sales gets aggravated about, that legal gets aggravated about. I assume that there's not generally a lot of back and forth with legal about, choice of law or whatever, what jurisdiction we're going to litigate in. They're probably going back and forth on a few key terms. So let's talk about those payments. When you and I were in contracts class, it was like, I'm going to pay you on this date, and this is what you get in return. The simplest form of a contract. Talk to me about payments and where sales and legal are starting to butt heads.
Well, I think the key thing that we can do as legal on the payments is just to make sure they come in at as needed, and that we control the disputed invoice clause. So you see, I think one key thing, if people on this call pick up, is that to allow undisputed invoices that's the only thing the customer will pay. To me, that's an immediate area for legal to add value, just to put some boundaries around. Well, what constitutes a dispute? How do we deal with it? What's the timeline to deal with it? That's a simple one. Then you get into the other stuff that's a bit more complicated, which is really understanding how to contract around the data that you're taking in, how to deal with termination. And I think the payment on termination, how people can terminate, how they can get out of the contract. That's where we kind of live on the business terms that sales can have a lot of input on. And then when we get into what I call the strict legal terms that just generally don't come up in the sales process, those would be the liability caps, the indemnification. And I am always a believer in the client can know a bit or enough about those topics to just not feel at sea when they come up. Because I think a bad thing that happens is just thinking it's someone else's job to think about those things. is its own problem, because you do have to be aware of what the risks are in your own product and understand how to sell with those risks incorporated.
So clear terms, clear termination. But I do want to ask about the strict legal stuff, because it feels like the legal team is not going to understand what indemnification and what these liability, they're not probably going to really go take your class on indemnities. So how do you fix that? Because that will be a holdup, right? If the salesperson is going out and they're saying, this is the offer, and the other side comes back and they say, well, we want indemnity capped at whatever. Now it's going to come back to you. You're going to be the holdup because the salesperson doesn't know what the heck an indemnity is. So how do you, when that transfer does happen, when there's that moment of we need a decision to be made about this thing, it seems like it's inherently going to frustrate sales because their brains, like, how do you get their brains wrapped around that?
Well, I think that's why you get senior management decision makers, the people who have the final signing authority, which typically is not sales. It usually has to be approved by finance. There are certain business approvals that have to happen. And so what often occurs is that there's this like final showdown between legal and sales, the eve of the deal supposed to close, and someone in the decision-making capacity has to make a hard call. And usually it goes something like legal saying there's too much risk, sales is saying this has to close, CFO is looking at what revenue is needed for the year, and so they close it. But to me, that can be a failure on the lawyer's side, because why did we get to that point where we're talking indemnities with the CFO only on the eve of the deal? There should be a scenario where you've discussed what the optimum provision is. The lawyers typically aren't making the decisions on these deals. They're advising of risk, they're proposing language that's best for the company, and at the end of the day, someone else is going to make the call. So I think to bring the sales team in very simply, and I agree, nobody, including frankly, maybe sometimes lawyers, wants to be in an indemnity discussion. But even to just say, here's where this would come up. Like, this is where you would have sold a deal where we're on the hook for their costs if they want to sue us for not doing what we said, because it's an all claims indemnity. So I tend to not use the legal terms when I'm talking to the teams about it. I just say, so to put this in plain language, what we're talking about is the following, and that isn't okay with the company. So you can't sell that. How do we get around it?
To get tactical, to get practical, in most organizations, we're talking about who's copied in on an email, right? And obviously there's a lot to talk to about this, but I think that communication flow might be central to the point that you're making, which is like, if legal is copied in and sales is copied in and the leader is copied in, the decision, and everybody's pinging these emails back and forth, it's almost impossible for sales to see anything other than legal is stopping this, and legal to see anything other than, so I guess maybe I wonder if there's some way to have email is just awful. We all know email is awful. Slack creates a lot of other issues because it's the inefficiency of email plus the anxiety of social media. But like these kind of communications with that lack of flow, with everybody's just copied in, pinging in, is there a better way for those teams, to your point, to have structured conversations, to say at these stages of the deal, we're going to talk about these different things, so it's not either last minute or vague BCCs in the background?
Yeah, the way to get in front of it is to have a process where it's like, here's the template, and we really thought through what the template says. So your standard agreement, it should be something where you are prepared to stand behind it because you have to. To me, put the document out there that you will stand behind. If every single time you're backing down on what you have in the document at the last minute, something is wrong.
Well, and sales will know that, right? Like, as soon sales will be like, the contract doesn't really matter. Yeah.
Well, and it will also affect the credibility of the team and even the senior management, because they are backing down on it. So the tool is the playbook. That the tool is, you go into the it doesn't have to be a formal playbook. It can also be an annotated contract where the decision makers have said, in these circumstances, and you can actually lay out, and we do with most of our clients, This circumstance, no movement on the terms. This circumstance, possible you can accept or propose this language. This one, this. And then if you can't get any of these, goes to the CEO or the CFO or whoever the approval process matrix says this issue goes to. And that is just, everyone knows the plan, you know, as opposed to it's the lawyer's kind of like decision of how this is going to get to the end goal, which is honestly how it works often. And
That
it
is an
shouldn't be.
excellent pivot, Darlene Tonelli. I'm going to tell you one of the smartest things that I have ever said as a manager, and I want everybody to hear this because there's so few smart things that I say, but it is easier to manage paper than to manage people, right? And what we've just had this whole conversation about was how to manage people, how to deal with people, how to interact with people. And you see the complexity and the difficulty of that.